I want to thank everyone for joining us today for the Fair Credit Reporting Act's requirements for employers. I'm Mike Coffey, President of Imperative Information Group. This webinar is part of an ongoing series that we do for our clients and our friends in the HR community, talking about the various legal and practical issues surrounding the use of criminal history and employment-related background checks. I'm an HR guy. You see it all on the screen there. I've been in and around HR most of my career, and but the real takeaway from all of that is that I've had the opportunity to work with a lot of really smart HR people, and a lot of our clients are really great HR people. And so some of what we're going to talk about today are things that I've taken away from working with them, and so while I won't acknowledge them individually, I will say that I've learned a lot from our clients, and you'll hopefully benefit from some of that today. So let's start with a real quick poll. I'm curious if you just kind of assess for me your own FCRA compliance. How sure are you that your company is FCRA compliant? We'll just take a few minutes here to assess that. Okay, we'll wrap it up here in just a second. Okay, let me close that and share the results. There you go. And so 25% of you are very sure. That's great. I hope those are all our clients. About half of you, a little less than half, are fairly sure. A quarter of you aren't sure, and at least a couple of you are just, you know you're in a hole. And so hopefully we can help you get out of some of that today as well. Well, the Fair Credit Reporting Act is a federal law that governs the use of background checks. Specifically, it governs the use of consumer reports. Now, they call the law the Fair Credit Reporting Act, and I'm going to say right up front, ignore the word credit. It ought to be called the Fair Consumer Reporting Act. But when the law was written and ratified in 1971, the idea was that this was primarily about credit reports. Now it's because just the way our industry has changed and the way employers are using all kinds of background check information more commonly, we should really just ignore the word credit, because there's so much more involved there, and that's one thing that does trip up employers from time to time. And when employers get tripped up on compliance issues, they pay. The plaintiffs bar has figured out that this is a great way to make money, and it's kind of a shame because this is a really easy law to comply with from the employer's side. It's a much more complex on the background screening company side, but from the employer side, this is not a hard law to comply with. But you see that these are just in the last 3 or 4 years. These are class action lawsuits that have settled for millions with companies that really ought to know better. And then in the last 18 months, we've had a whole rash of cases filed against other well-known companies simply because they weren't compliant. And we'll talk about the ways they weren't compliant, or they were alleged to not be compliant in this case, throughout the webinar today. But I bring this up now just to tell you, again, this isn't a hard law to comply with, but many employers, either because they didn't get good information or consulting from their background screening partner, or just along the way something broke down, often they get bad advice from their own employment law counsel. A lot of, and I speak at conferences all over the country, and I talk to a lot of employment law attorneys, and a lot of them don't understand this law, and some of them are getting their clients sued. We'll talk about some of that here throughout the day. So the Fair Credit Reporting Act deals with consumers, and now a consumer is an individual, okay? So it's a person. So if you're dealing with a company, it's probably not a consumer report. If you're running a background check on a vendor who's a corporate entity, and you just want to see if what their civil litigation history looks like before you enter into a deal with them, that's probably not a consumer report. But if it's an individual who you're looking to hire for a specific role, or even as a 1099 type contract employee, something like that, he's an individual, then it probably is a consumer report under the law, and you need to pay more attention to what we talk about today. So basically, a consumer reporting agency is your background screening company. Where you're getting your information for a fee. So if I'm selling you information about your applicant or an employee that you're going to evaluate, use to evaluate their employment, it's a consumer report. And this is, so in a consumer reporting agency is your background screening company, or it may be also somebody like the Work Number or the National Student Clearinghouse. Those are both examples of companies that you go and you buy information from your applicants. So they wouldn't necessarily consider themselves background screening companies, but they are consumer reporting agencies under the law. And so even if you do all of your background screening in-house, when you call a former employer to get a reference, and that employer tells you, well, actually you have to call the Work Number because they do all our verifications for us. As soon as you call the Work Number or go to their website and pay a fee for that information, you just bought a consumer report, and everything that we're going to talk about today will apply to that transaction. The same for the National Student Clearinghouse, which verifies college educations. If you don't hire someone because they didn't have the degree they claimed, then you've got to follow the Fair Credit Reporting Act. And before you order the information from the Work Number or the National Student Clearinghouse, you also have to have all the consents and authorizations that we're going to talk about. So what is a consumer report? It's not just a written report. It's any information you get from a consumer reporting agency bearing on the individual's character, general reputation, personal characteristics, or mode of living that you're going to use for employment purposes. That's a consumer report. And so let's go through this: character, general reputation, personal characteristics, mode of living. So we're talking about a background check, and it's got their credit information. Well, that goes to certainly reputation, mode of living, perhaps character, and certainly those other things, credit capacity and credit standing. Let's say you're going to do employment verifications. Well, certainly somebody's mode of living, their personal characteristics. Oftentimes, if you talk to a former supervisor, you'll get information about character, general reputation. You can check their criminal history. There's character, there's general reputation, perhaps mode of living. So all those things would apply and would make the information you're buying from a consumer reporting agency a consumer report. And so I'm going to use the term consumer report and background check interchangeably in our context today. As far as what we're talking about, they're the same thing. And it does mention that it's got to be used for one of many purposes, but one of those purposes, and the one we're interested in today, is employment. And so it's not just the pre-employment aspect of the employment relationship, not just employment applicants. If it's a current employee and you want to run a background check, we have clients who do background checks on all their employees annually. And we have clients who run driving records on all of their employees annually. Or they have some sort of continuous monitoring of their employees to see if any of the criminal record sources identifies a new record on them throughout the year. All of those would be employment purposes. So it's not just the initial employment, it's anything related to their employment through the employee life cycle up to the point that they're terminated as an employee. Now there's a special kind of consumer report called an investigative consumer report, and basically that happens when we talk to someone, primarily in the employment context, it's former employers or former coworkers, or we do personal references, and we interview the person about, you know, what kind of employee was Joe? Did he show up on time? Did he get along with others? Those kinds of things. So it's not just black and white information out of your HRIS system or your payroll system about date of hire, date of termination, job title, salary, things like that. We're now getting into more qualitative kind of information. We're conducting interviews. Even if it's just 2 or 3 questions, it's an interview, and so that makes it an investigative consumer report. Now, really, practically, from the employer side of this equation, it doesn't make a giant impact on you because most employers assume that all of their reports are going to be investigative consumer reports, and it's not a lot of extra work. It's no extra work for you to structure your background check consent, disclosure and consent forms so that it deals with both investigative and regular consumer reports. So what about references? This is a question employers ask a lot. So does that mean every time I call to check references, it's a consumer report? And the answer is no, because when you're getting information directly from someone who has dealt with that individual, former manager, and so you as the HR professional or the hiring manager, you call that employee's former supervisor, and they tell you, yeah, Joe was a great employee, he showed up on time, and we didn't really have any problems with him until he burned the warehouse down. Well, that's not a consumer report, because you're getting that information directly from the source. So they're sharing their own transactions or their own experiences with the consumer. Now, the difference is that you go to your background screening company like us and you say, well, we want you to call Joe's former employer, and we do it. And they say, well, yeah, Joe's a great employee, but he burned down the warehouse. And we tell you that. So it comes through this third party. That makes it a consumer report. And so that's kind of, if you're getting it directly from the horse's mouth, it's not a consumer report, but if you as the employer are getting it through a third party, it probably is. Now there's another exemption to the term consumer report that deals with investigations into employee misconduct or compliance with company policies. So if you're bringing a third-party investigator, either your outside counsel or an HR consultant, somebody like that. We do that for our clients. You would need an investigation into, sexual harassment complaint, or somebody's not following company policies and we got a problem. Whatever. Bring a third party in to do an investigation. As long as it's related directly to this allegation of misconduct or compliance with state, federal laws, things like that, then it's not a consumer report, except that you do have an obligation, and a lot of employers miss this, that if you take any adverse action, and that's adverse, any action that's negative from the point of view of the employee, based in whole or part on that report, then you need to give that individual, that consumer, the employee, a summary of the nature and substance of the communication. But you don't, so you can say that you were, accused of sexual harassment. We brought in our HR consultant. They did an investigation, interviewed employees, and it was determined that it was likely that you violated company policies with regard to sexual harassment, period. So you don't have to say that Mary said you touched her inappropriately. You don't have to list all of those kinds of issues in the report, even though your HR consultant or your attorney or your investigator may have told you those things. You just have to give them a summary of the information. So let's get started with the process of ordering a background check. consumer report, before you ever order the first background check from your background screening partner, under the federal law, you have to certify who you are, your permissible purpose for requesting the consumer report, and in our context, again, today we're talking about employment purposes, that you have to certify that you're only going to use it for the purposes that you're obtaining it for. So you're going to use it for employment purposes and not for extending credit to a consumer. So you're not going to order the report as an employment report, but then make a loan decision based on that. And you're not going to use it for any other purpose like embarrassing the person or giving it to the media for, to write a story about or anything like that. You've got to certify that you're going to comply with the Fair Credit Reporting Act's disclosure and adverse action requirements, and we'll get into those in just a bit, and that you're not going to use the information in violation of any equal opportunity laws. So you're not going to use it to discriminate against people in protected classes. You also have to certify that you'll disclose to the consumer, to the individual, that you're going to or have ordered an investigative consumer report, and that upon request you'll provide the nature and scope of that investigation to the consumer. That's all just stuff you've got to certify to your background screening partner. And if you're using a quickie database company over the internet, you need to be careful, because a lot of times those aren't Fair Credit Reporting Act compliant information sources. And so if you go online to just do a quick background check, instant criminal background check online from some database that's selling the information, if there's no place along the way where they ask you to certify all this information, that should be a red flag to you that maybe this isn't an FCRA compliant source, and you may be violating the law by using that information. So once you get all the paperwork set up, which for most consumer reporting agencies, it's fairly standard and streamlined, it's time to order your first background check. The first thing you've got to do is disclose to the consumer that you're going to procure the consumer report. This disclosure has to be on a separate document. So the disclosure cannot be the small print at the back of your employment application. It's got to be the information, it's got to be a clear, and let me look at this. Next slide says it's got to be a clear and conspicuous disclosure. And it can't have other information in it. This is one of the sources of a lot of litigation. A lot of employment law attorneys are slipping in releases of liability or hold harmless clauses inside these disclosure documents. And this is one of the allegations against Domino's Pizza. In fact, the court ruled in a Domino's Pizza case, which was settled, I think, for $2.5 million, that Domino's disclosure document on its face violated the FCRA because it had a release of liability. So their release of liability cost them $2.5 million in liability. So I would suggest that you go back and look carefully at your disclosure document and see if there's anything in there that maybe shouldn't be. Then if it's an investigative consumer report, in other words, especially if you're going to be having your background screening company do any kind of reference checks or talking to former supervisors, things like that, employment verifications that go beyond just name, rank, and serial number kind of information, then you need to have specific language on that, disclosing to the consumer that you're going to order an investigative consumer report. And it's got to say, we're going to order an investigative consumer report, and it's got to be, this information is going to be provided to that consumer in writing. And a lot of most employers just get that right up front when they do the initial disclosure document. But if for some reason you didn't you got there authorization to procure a consumer report up front, but for some reason you didn't have their authorization to do an investigative consumer report, it can be mailed to them within 3 days after you've requested that. And then you also have to include, and this is where we get into semantics, a statement informing the consumer of his right to request the nature and scope of the investigation and the written summary of rights of the consumer. There's a document called Your Rights under the Fair Credit Reporting Act. And we'll talk about that a little bit more when we're talking about the adverse action process. But the way this clause is written, some employers read it saying that it's got to have a statement informing the consumer of their right to request the scope of the investigation, and in addition to that statement, it also has to have that written summary of the rights of the consumer, which is a 3-page document from the Consumer Financial Protection Bureau. Other employers read this as meaning that the statement itself contains the consumer's right to request the nature and scope and their right to request a written summary. So what most employers do is split the baby down the middle. On their paper applications and their paper consent forms, they just leave that written summary, as they don't attach that whole multiple page consumer reporting, summary of consumer rights document to the disclosure document. But on their electronic applications and their electronic disclosure documents, they often have them attached right there because and the reasons are obvious. Employers don't want to add 3 additional pages to their application or employment hiring process to give to consumers. So, and the law is really ambiguous on that. The most conservative thing you can do is with the disclosure document to go ahead and give them the statement of their rights to the multiple page document. But most employers don't do that, and it's not something that we tell clients they need to be really overly concerned about doing. We haven't seen any litigation in that area. So here's what the sample disclosure language looks like that we give our clients, and you don't have to write this down or do a screenshot. I will send everybody who's attending a link to download all our slides and notes. But it's pretty straightforward stuff, probably very similar to what you're using already. Now the other part of that disclosure piece is just telling the applicant that we're going to order a background check and it's got to be on a separate document. But then you have to go back and get their authorization. You cannot order the background check without their written authorization. Now many employers include, almost all of our clients include the disclosure document and the authorization on the same document. So that disclosure language and the authorization are all together. The reason you do that is because you want to have proof that you gave the applicant that disclosure document and that it was a separate document used exclusively for that purpose. So the law allows the authorization to be combined with the disclosure, and so now they've signed it and given it back to you, so now you have proof. And there are a lot of these class action lawsuits are focused on whether the employer's disclosure document was used exclusively for that purpose. Now you can also have your written authorization as part of the small print at the back of your employment application. It's not strictly, it's certainly permissible, and there's nothing that says it has to be included on the disclosure document. And what we recommend actually is if you're next time you redesign your employment application, go ahead and stick that same authorization language into the small print at the back of your employment application. So you've always got that authorization, because sometimes you may need to have a copy of the authorization to share with a former employer or a school that wants to see it, and so you've got it right there as well as on the disclosure document as well. So we suggest you put it in both places. But that's me. I'm a belt and suspenders kind of guy, and it's just It doesn't hurt anything to have it there, and so you've got an extra one. But you can combine these, and that's what all of our clients do, and almost every employer I've ever talked to does that. So this is what it looks like. When you combine those two documents, up here at the top, you see you've got the disclosure language right up at the top. And then this is our standard form. At the bottom, you've got the authorization information. And they've authorized it. And there's nothing here in this document that is anything other than consumer reporting information. So you've got it all in one place. So you order the background check, and now the report has come back on your applicant, and you're looking at it, and you say, ooh, well, that causes me a concern. The applicant didn't tell us on the application about this misdemeanor theft by check case, and so I'm concerned about that. So let me decide what we're going to do. Well, as soon as you see the information and it may adversely impact the hiring decision, before you take any adverse action, you've got certain responsibilities that kick in, and that means that first you give them a copy of their report and their rights under the law. This is that summary of your rights under the Fair Credit Reporting Act document I was talking about earlier. This is before you take the adverse action. Now, an adverse action would certainly include not hiring the person, but it might also be some other characteristic of the job that changes because of the information on the report. For instance, let's say you were going to hire an outside salesperson, and you got this great candidate with a great work history, but you know what? He's got a DWI that's 6 months old, and we're just not comfortable as a company putting somebody in an outside sales position where they'll be driving their personal car with a recent DWI. We want more experience with this guy and have a better sense of who he is before we let him loose behind the wheel of a car on company business. So we're going to offer him an inside sales position. We want to keep him. We don't want to lose this great candidate, but we're going to offer him an inside sales because we don't want him on the outside sales yet. That would be an adverse action from the point of view of the consumer. Another one is we've got clients who hire paramedics, and they pay their paramedics based on the time that someone has actually ridden in an ambulance. So they may be looking at the employee's application or the applicant's application and say, well, you know, he worked his title at the hospital system where he worked previously was paramedic, and he was there for 4 years. So we're going to offer him, you know, pay based on 4 years of paramedic experience, and so we're going to pay him, you know, $25 an hour. But then during the background check, we determine, oh, well, that's true. He worked for that company for 4 years, but when he was at the hospital, he spent most of the first 3 years he spent working in the emergency room, and only spent 1 year in an ambulance as a paramedic. And so the employer is going to alter the equation of what they ultimately offer this applicant. And in that case, I would suggest the safest route is to treat that as an adverse action. So go ahead and give the applicant a copy of his report and a copy of his rights under the law. And if there's ever a question as to what the right thing to do is, go ahead and give it to them. It never hurts to give the applicant a copy of their report and their rights under the law. Clients call me from time to time and say, hey, this applicant asked for it, and there's nothing negative on it, but he asked to see it. Can I do that? Yes, please do. Share it with them as much as if they ask, give it to them. There's no reason not to. And just as an HR point of view, you know, there are employees out there who are always convinced someone's out to get them, or that there's some secret meaning to whatever happened, and that they're always concerned that they weren't treated fairly because of something that was out of their control and they didn't know about. So if an applicant or employee asks for a copy of the report, go ahead and give it to them. It won't cost you anything. It doesn't create any liability for you. And it's just, it relieves any doubt that they had that they were treated fairly. So I encourage you to do that. If there's ever a question, though, just think about it, if the report in whole or part affected the decision about any of the terms or conditions of employment or whether to even hire the person, it's an adverse action, and go ahead and give them this information before you take that action. Once they get that information, they can dispute the information back to the consumer reporting agency. So they can call the background screening company and say, hey, the information on the report is wrong, and I need you to go, fix it. That may be, criminal information that isn't reflected or doesn't belong to that person. If you're relying on criminal records databases as your background check, you probably see that a lot, where they often connect the wrong person to a criminal history, or they have old information so it shows that somebody received deferred adjudication, but that deferred adjudication since the time that the individual record was put in the database has been dismissed, and so it's not up to date, and database records should never be considered up to date. As soon as they sell the information, as soon as that information goes into the database, it's out of date. So you may see something like that out of a database pretty routinely. You may also on occasion see information that a consumer wants to dispute where they where the background screening company contacted the former employer, and the former employer said, no, he's not eligible for rehire. Well, the applicant or his attorney called the employer, raised a fuss, and the employer agreed to say that either that he is eligible for rehire or that they don't make that determination. And so suddenly they'll make all those calls, and then they'll call the background screening company and say, call this company and verify this information. They're going to give you something different now. And that happens on occasion. It's real rare, but it does happen. So they can always dispute the information. The background screening company has 30 days to reinvestigate this information. However, there is no requirement for the employer to hold that position open during that dispute investigation. Now, if you're dealing with a good background screening company, they're going to get any dispute that comes along completed often within hours, almost always the same day or the very next day. It's just extremely, for us, anytime we talk to a consumer, we take it very seriously and make sure that we verify the information. Often that means picking up the phone and calling a courthouse or calling a former employer. We never want an employer to lose a good candidate or have their reputation hurt with a good candidate because some court information someplace was not correct, or some employer has since changed their records. So if you're working with a good consumer reporting agency, they're going to get that fixed as quickly as possible. Then once the applicant has received that copy of his report and his rights under the law, the employer has to provide another notice after they take the adverse action. So you give them a copy of their reports and their rights, and then you make the decision, okay, we can't hire this guy, or we're going to offer them a different position or less money, or you name it. The employer, after they take that decision, take that action, make that decision and put it in place, you've got to give them another notice that explains that, hey, you're taking this adverse action. Then you also have to tell them how to contact the background screening company, the consumer reporting agency, and it's got to also include a statement that the consumer reporting agency didn't make the hiring decision. That's something I guess my predecessors in the industry decades ago got in there, just so we can make sure that we tell that the consumers, the applicants who are angry that they didn't get hired, when they call us, they've already been put on notice that, hey, we're not the ones who decided not to hire you. So that needs to be all in the language. And most of your good background screening companies, their automated systems will automatically print these letters for you. We send them on behalf of many of our clients at their request. And so your background screening company will handle this for you probably if you'll ask them. Now, a few other things about the FCRA. It has a lot of requirements on what the background screening companies do, and it limits primarily, from your point of view, what we can tell you, what a background screening company can tell an employer. Negative information is pretty much limited under the federal law. So criminal convictions under federal law are reportable forever. I can tell an employer about a 1971 conviction for shoplifting. Convictions are reportable forever under federal law. Now, there are a few state laws that limit what a background screening company or consumer reporting agency can tell an employer, California being an example. However, most states don't have those limitations. But this is the reason you see the criminal history question on employment applications is often, have you been convicted in the last 7 years? And this 7-year rule is where it comes from, although convictions are reportable forever. Before that law changed in 1997, and before 1997, they weren't reportable after 7 years. They changed the law in 97, but that 7-year criminal history question has stuck around, and that's still the reason a lot of background screening companies only offer 7-year criminal record searches. Our standard search is 10 years, and for some clients we go further back. So convictions are reportable forever under federal law. Now, also under federal law, non-conviction cases are reportable for up to 7 years. And so if a case was dismissed or the person got deferred adjudication and served probation and the case was dismissed, or they got some sort of pretrial intervention, any of that is reportable under federal law for up to 7 years. And if the person's going to make more than $75,000 a year, everything is reportable. So, and $75,000 a year seems like a low threshold for that, but you got to remember, this is a very old law, and at the time that part of the law was enacted, somebody who was making 75 grand a year was a highly compensated individual, and so they felt like, well, for executives or really senior professionals, employers ought to be able to know more about them, I guess. But since then, 75,000 is not nearly as significant a hurdle, but a lot of them, the law still is set there at 75,000. But anything, if it's reasonable to believe the applicant's going to make more than $75,000, there are no limits on even non-conviction information. Now, in the area of civil cases, liens and judgments, and credit items, again, it's that same 7 years or $75,000 rule. And the only one exception to the 7-year rule is bankruptcies, which have a 10-year rule. Now, some states do have their own consumer reporting laws that govern what employers can do. We're based here in Texas, and Texas on the books in the Texas Business and Commerce Code does have a 7-year limit. However, it was passed after those 1997 federal law changes were passed, and the Federal Fair and Accurate Credit Transactions Act, FACTA, invalidated any state laws limiting what a consumer reporting agency can report if those laws were passed after the 1997 changes to the federal law. So Texas's law is on the books, but it's invalid. But there are other states that have some sort of unique requirement, and so in each state where you're working, you want to make sure that you've checked with those states to make sure that you understand. Your background screening company should partner with you in that and tell you about the specific state-specific requirements. And now on top of that, you've got things like ban the box and those kind of considerations. A good example of states that restrict what employers can consider is Massachusetts. In Massachusetts, they've passed ban the box, so that means that they've delayed the criminal history inquiry until later in the employment application process. So you fill out the employment application and they don't ask about criminal history in Massachusetts. That has to happen after an interview, and I believe there are 6 states that have passed that for private employers, and another 7 states on top of those for public employers have some sort of ban the box legislation. I've got a whole webinar on criminal history inquiries called Outside of the Box, creating an effective criminal history inquiry, and we get into all of that stuff. They've also in Massachusetts got employers can't consider misdemeanors older than 5 years and felonies older than 10 years. So there are specific things state by state that you may want to be aware of. And then there's California. California has special considerations for sex offenders. Employers can't consider anything that didn't end in a final conviction. They've got protections for marijuana users. Convictions in California can only be reported for 7 years, so I can only tell a California client, and we have some of those, who I can only tell them about convictions for 7 years, including murder, rape, arson, you name it. So if somebody was convicted of murder 10 years ago, I can't tell a California client about it as much as I would like to. And there's all kinds of special paperwork that's required in California as well. I believe there are 10 states still, there may be 12 now. My numbers off the top of my head aren't so great, but that restrict the use of credit reports by employers. Most of these are pretty generic restrictions. They just say that the review of that information has to be job related, but some others prohibit or delay it until late in the hiring process. So again, you should work with your background screening company to understand the specifics of the states where you're working, where you have work sites and where you're hiring people, to make sure that you're compliant with those state-specific laws. There's also ban the box, which again is the movement to delay the criminal history inquiry until later in the process. We've got a whole bunch of stuff about ban the box on our website that may be helpful to you if you think that's something, because even some cities like San Francisco have passed their own ordinances considering ban the box. So let's go to questions, but first I want to do a quick poll. If you have questions, drop them in the question box, please. And let's do this quick poll. I just want to see if this was worth your time and mine. I hope you learned something. So if you'll just answer that simple question for me. It'll either validate me or make me go get a drink with my lunch. I'll let y'all answer those. Okay, about half of you have voted. There's 69, 63, 64. Am I going to get any more? 66. Okay, 73 now. See, I'm putting the pressure on you. 76, 75. Wait, somebody unvoted? Okay. Okay, we'll close it at 75% voted. And let me share those results for you. Okay. Well, thank you. I'm glad this was worth your time. 87% of you said that, in fact, yes, you did learn something that is hopefully going to help you change your practices. Now, before you change your practices, let me suggest to you that you want to go ahead and talk to your background screening company. If you don't have a lot of confidence in your background screening company, and I know some of you don't, because I talk to employers all the time who are with the low price option, but it's also the lowest value option, and they don't get the consulting and support that they need. So you may, in those cases, want to go talk to your employment law counsel besides just your background screening company, or certainly feel free to give us a call. I'd be glad, even if you're not one of my clients, I'd be glad to share some information with you if there's something I can be of service with. So let's go into questions. If you have questions, drop them into the question box here, and let me get to the first one. Got several here. Okay, can you do a background check on an applicant before an offer is made? Everywhere but Hawaii, you can. Hawaii is the one state that delays the criminal history inquiry at all until after you've made an offer. But off the top of my head, there aren't any other states that come to mind that require an offer to be made. And we do have clients, most of our clients probably do the background check right before they make an offer or right after. Often they make an offer contingent on completing the background check successfully. And if you've got a good process in place, let me just say this is not really directly related to the FCRA, but if you've got a good process in place, you've got a good criminal history inquiry, you've got good interviews, and you ask all the right questions, there should be no surprises on the background check. All the background check should be is validation that the applicant told you the truth during your hiring process. Now, thank heaven so many of the applicants are dishonest, because I'd be out of work otherwise. And we do constantly have employers who are surprised by the background check, but that's on the applicant. And so if the applicant lies, you can certainly make a hiring decision based on that. Now, is it better to do the background check before the offer or after? I don't think that's specifically an issue either way. It's going to really depend on how hard is this position to fill. For your more difficult to fill positions, especially if you've got a strong second candidate that's in a hard to fill position, you may want to run the background check earlier in the process, just in case your first candidate washes out based on the background check. If they're disqualified because of specific criminal history that would disqualify them, or their employment or education history doesn't check out, those kinds of things. In those cases, you may want to run the background check later, earlier in the process, so you don't lose that second candidate. We do have clients who on occasion will run both of their final candidates just to make sure. And sometimes it comes down to, if we're doing the employment references on both the candidates, it comes down to how strong were the references between these two applicants, and that makes a decision impact on the hiring decision. California employers cannot make employment based on decisions. California employers cannot make employment-based decisions on sex offenders, correct? That's generally correct, Jessica. There are a few specific kinds of jobs where that can be a factor, but generally they do have protections for sex offenders in California. I speak to former offender groups from time to time, and they, these are former offenders with often pretty significant criminal histories, and they're trying to, find work. And I usually talk to them about how to find meaningful work if you've got a background, and we've got a training program we do for former offenders on that. But sometimes they'll come up to me afterwards and they'll tell me what their history is, what their criminal history looks like, and I'll suggest, it's going to be a problem for you as long as you're in Texas working for any kind of employer that does any kind of decent background check. So, you might want to consider moving to California just because after 7 years you've got no history there, and that may be your better bet. As a Texas taxpayer, please move to California. In the next question, in the DOT industry, the MVR would be a consumer report. Yes. If you're getting the MVR through your background screening company, yes, it would. Now, if you're getting it directly from the state, it wouldn't. But let me finish your question. During the pre-screen process with the applicant, if we do not move forward with an applicant due to a DUI, et cetera, I would still need to send an adverse action letter? Oh, yes, definitely, Lorraine. No, hi, Lorraine. How are you? I just realized who it was. Yes, that's true. If you, if there's anything on if it's a consumer report at any point in the process is going to affect the hiring decision, then you've got to follow that adverse action process. Do the pre-adverse action and the post-adverse. Now, in those cases, like an MVR from the state of Texas, that if it shows a DWI or it shows, too many tickets to pass muster with your company policy for drivers, then that's what the state's record is, and it's very unlikely to change. And even if the consumer disputes it to me, all I can do is send that dispute to the state, and they're going to stand by whatever's in their records. And so the person's not going to be hireable, but you still got to follow this process, give them a chance to dispute it, and then make your decision. Okay, let me see. Next question, from what I understood, I would like to confirm this is correct. The employer should send a copy of the report, then the FCRA writes. Yeah, those two go together. Yeah, that's the pre-adverse action. You want to send a copy of the report and the summary of consumer rights, then send the adverse action letter after. Yes, that's true too. Can the employer have the background check company send this all together on their behalf? Yes, they can, but not in one envelope. What you want to do, the whole point of the law, just think about it's easier to understand if you think about what they're trying to accomplish with this process. They want the applicant to be able to see the background check and say, hey, this isn't right, this isn't correct, before you make the decision. That's the whole point. And so you can mail it to them, mail the report and their rights to them. And what we do, when we do it on behalf of our clients, we do it, typically what we do is send that pre-adverse action letter certified mail, and we send it regular mail. We send it twice on the same, they both go out the same day, but we send it twice. That way I've got proof that it was delivered because of the certified mail, but they get it more quickly, regular mail, but especially if they are working during the day and the mailman comes by and knocks on their door for them to sign for the document. If that way, they can't say that the certified mail delayed delivery of the information to them, so we send it regular mail as well. But that's true. Your background screening can do that. Company can do that on your behalf. Now, our system, and I imagine others too, also has a way for the employer to initiate it electronically, and you can even if you've got the applicant's email address, you can drop that in and just hit pre-adverse action button, and it'll send an email to the applicant. And this is the employer doing this. It'll send an email to the applicant. The applicant will be given basically a login to see their own report. And as soon as they go look at the report, that information is recorded in our system with their IP address and the time and date and all of that. So we know exactly when the applicant received the report and their rights into the law. It's all together there in one screen. So they can print it, they can look at it, they can do whatever. And that link is good forever, so they can always go back and look at it if they want to, or print it. So that's another alternative, and that's really fast because you email it to the applicant, then you pick up the phone and say, hey, we just sent you an email, will you look at this, please? And while you got the applicant on the phone even, he looks at it and he says, oh yeah, well, I forgot about, and that's what they always say, well, I forgot about that 6 months I spent on probation for assault and bodily injury of a family member. Sorry, I just forgot about it. Didn't mean to lie on the application. Well, then you can make your hiring decision. Well, we don't, as a matter of policy, we don't hire anyone who is untruthful on their employment application. So we'll be sending you another notice to confirm that we can't hire you. That's the whole process. So it can all be done in person, and if you've got employees, you're doing background checks on employees, and you have to terminate somebody or take some action based on some employment action based on what came on your annual background check on that employee. Same process. You can do it all in person though. Call the employee in, hand them a copy of their rights and a copy of their report, give them a chance to review it, give them a chance to say whatever they need to say about it, discuss it, and then make the hiring, the employment decision, whatever it is. And that can all be done in one at a time. What is the typical language used on the employment application for use in multiple states to comply with different state laws? Oh boy, well, I have a document that we give our clients that's got as broad a language as you can use in most states, and then it's got specific carve-outs state by state. And that's probably what you want. You want to get that from your background screening vendor. What you don't want to do is, in my opinion, this is the gospel according to Coffey stuff, me putting on just my HR hat, and as an HR guy, I think what you don't want to do is have a criminal history inquiry that's limited to the most conservative states. So it would only ask about misdemeanors in the last 5 years because of Massachusetts, and 7 years felonies because of another state's laws. So I don't think you want to do that. If you're in a state that allows you to ask about their full criminal history, then you want to ask about their full criminal history. And then if you've got an operation in another state that is more limiting, then you just put an exclusion in there or have a specific question for those applicants. That's my recommendation. Let me see here. If a source is not contacted within 30 days, why does the element get removed? Okay, you're talking about disputes there, Hannah. And in the case of a dispute, the background screening company has to verify the information within 30 days. And if we can't verify it, we have to remove it. If we can't verify that the information on our report is accurate, we have to remove it. And that should almost never happen. If the background screening company was doing a good job on the front end, they ought to be able to verify the information that that they just provide, they just received within a couple days. That should be such a rare occurrence. It's never happened here at Imperative that we couldn't verify something. Now we have talked to employers who've changed their story after 30 days, or had changed their story after they initially gave it to us, and when we got a dispute, we had to go back and change the report because the employer changed what they told us. But we record every conversation, so we know exactly what they told us the first time and versus the second time. So, but that's just the way the cookie crumbles. But that's why things go away after they're disputed and if they can't be verified. Hi, Mike. Is any of this? Hi, Kat. How are you? Hi, Mike. Is any of this different for public safety positions? Police and fire do their own background checks. Should a municipality use the same forms disclosures process on the public safety side of the house? Yes, if you're using a consumer reporting agency. So we have municipalities who are clients, and we actually do the background checks for their law enforcement and other public safety positions too. Now, in many states, including Texas, law enforcement has access to this directly to the state's criminal records division, and will be able to get records that aren't otherwise available to the public, and they should certainly do that if they have that access. But if they, if they've been around very long, they know that their state criminal record repository is very incomplete. In Texas, the Texas Department of Public Safety's criminal records database misses a third of the people on death row. We found in a study we did in 2008, it was also missing records, a third of the misdemeanors and a third of the felonies across the state. So if you're if your law enforcement agency is relying just on the state's criminal records repository, they're probably missing records that you would find by going into the local courthouses where the person's lived, worked, attended school, and but they just aren't in the state's database for one reason or another. So our clients who have, our municipal clients who have public safety positions will even do their employment verifications and all of that stuff as well often. But anything you're getting from a third party like me, basically if you're paying for it to a non-governmental agency, it's a consumer report, and everything needs to be in compliance with everything we've talked about today. There's no exemption for public safety. If I want to do a background check in the US from the UK for a potential employee, does the FCRA still apply? We tell our international clients that yes, it does, because this is a consumer protection law, and so if the consumer is in the U.S. and then the law here is set up to protect them, and certainly we would have to follow it, and the law prevents us from delivering a consumer report unless the employer has certified that they're going to follow the Fair Credit Reporting Act as well. So we would require any of our international clients, and they're mostly Canada and things like that, if they're hiring a U.S. citizen to, or somebody who's not even a U.S. citizen, somebody who's in the U.S., that they would need to follow the Fair Credit Reporting Act as well. Let's see here. How would you advise an employer to make a hiring decision based on deferred prosecution results? Okay, deferred prosecution, deferred adjudication, pretrial intervention, these are all programs that courts have devised around the country to lighten the backlog of cases that, the courts are flooded. If every case went to trial, we would never get any, the case, it would take years and years to get anything resolved. So the courts have devised all these programs, often called first-time offender programs or things like that, pretrial intervention, pretrial diversion. In every program that I've looked at, if the defendant screws up during the probation, these programs typically require that the applicant plead no contest or guilty to the offense, and they hold that plea in abeyance. They put it aside, and then they assign the person probation, and basically they say, if you attend these classes, and you stay clean and you don't get in any kind of trouble for the next 6 months or the next 5 years, whatever the terms of probation are, then the case can be dismissed or not prosecuted fully later on. And so, and the cases are dismissed. So what we tell our clients is the person has engaged in that conduct, okay? So, or it's reasonable for you to believe that the person has engaged in that conduct because they've entered a plea of guilty or no contest. And if they had screwed up their probation, they would have gone back to jail. So the court was certainly willing to find them responsible for that offense if they had another infraction. So, or they failed to meet the terms of the probation. So our advice to clients is always look at the states where you're in, because there are state-specific limitations on that. California comes to mind. But generally, if you can make the decision, if it's reasonable for you to believe the person engaged in that conduct, you can use that information. And so then you have to decide, okay, is it, because he served 6 months probation for this family violence offense, is it reasonable for me to believe he engaged in that conduct? Yeah, I think it is, because I can guarantee you that state licensing agencies would definitely review that as though he had engaged in that conduct when they were making hiring decisions. And you can go look in a number of states, especially in areas involving patient care, CNAs, nurses, things like that. They're really concerned about even deferred adjudication or pretrial diversion. So that's something else to, again, that's gospel according to the Coffey stuff. I'm an HR guy, and my goal is always to hire the safest, most competent workforce that's available for the budget. And so, I just don't think that employers need to go hire people who are going to be management problems down the road. So, especially if they pose a risk to the public or to the population that you as an employer serve. We had an insurance company who ran our MVRs annually. They would report back to us if they were going to exclude any of our employees from our policy, but they said it was against the law for them to share the MVR results. Is that correct? Against the law, that would be a state law issue. I don't know. That would be a state law issue, and I don't know that that's accurate. I haven't heard of a state that prohibits employers or the insurance companies from running MVRs. What I would do in that situation, from sharing the MVRs that they run, what I would do in that situation as the employer is say, fine, that's fine, we know better than try to argue with an insurance company, right? So what I would do is just turn around and order the driving record on that employee myself through our own screening partner, and then make the hiring decision that, hey, he's not eligible for hire based on the information received from the insurance company. They want to insure him, plus we've just run this driving record and he's got this record, these records on his driving history, so we're going to make this hiring decision based on that. That's how I would probably handle it in those circumstances. I think it's possible that the insurance company may be setting themselves up, though, for some liability in that case, because it's, I would argue that the claim could still be made by a plaintiff's lawyer that MVR is still a consumer report, because it's doubtful that insurance company went directly to the state and pulled the directly from the state. They used probably some intermediary or some software company or somebody who pulls it for them, which would make it a consumer reporting agency probably, and that would make that MBR a consumer report. So they're pulling consumer reports, and it's affecting an employment decision. Even though it's insurance underwriting, I think they may be creating some liability for themselves. I'd be really cautious if I was the employer and make sure I covered myself very carefully there. How does this apply to states like Florida, which is a right-to-work state? Makes no difference. This doesn't have anything to do with right-to-work or any union issues at all. If you're, this is federal law, so just because, it's employment at will or a right-to-work state, that makes no difference in any of this. You don't have to have any kind of employment contract for any of this stuff to kick in. One more question. Most of the time, actually a couple more questions. Most of the time, the applicant will provide the MBR directly from the state DMV. I do not have to provide an adverse letter if they provide, but naturally I would give them the time to refute and follow up with us. Okay, and Lorraine, that's a DOT question, and here's the problem with that's fine. If you're taking action based on what the applicant gave you, certainly if it came directly from the applicant, it's not a consumer report. A couple things though, let me just give you a little bit more gospel according to Coffey, but applicants lie, and some of them are very devious. And so how do you know that that MBR that applicant is giving you is really theirs? So what I would want to see is that they sit down at your computer in your office and print it out from the state, directly from the state's website in your office. I would want to see them print that. That's the process we also give clients who need one credit report a year, and they don't order credit reports enough to justify the expense of getting set up with the credit bureaus to run reports. So what we advise that they do is go ahead and just have the applicants pull their own credit reports, but then have the applicants show up in their office and print them there, because we have seen employers who have applicants just provide their own credit reports, and then the applicants sloppily sometimes have doctored those credit reports and tried to make themselves look better. And so it's better that you they cut and paste it into Word or whatever and make it look better. So it's better that if they're providing their information that you see them print it from the original source. Now the other question though on the DOT side, and we have a whole webinar on DOT background checks, but on the DOT side, the applicant cannot provide their driving record. The Federal Motor Carrier Safety Regulations require that the employer requests that information from the state, not the applicant. Now, your background screening can do it on your behalf, but having the applicant provide it to you is probably not compliant with the FMCSRs. That's off the top of my head, but I think that's probably something that would be questionable. I think the DOT would like a better chain of custody on those MBRs than coming through the applicant. Let me see what else we've got. I've answered all your questions. That's good. Going through. Okay, good. That's my last question. Well, I appreciate, there's always a lot of questions. I appreciate so many of you stuck around through the even the question period. We will be sending an email out later on today that has a link to download the slides, and it'll have our notes too. So the notes are have a lot more information than just the slides did. And also a link to watch the recording of this webinar again, which is maybe helpful or something you want to share with your peers. And there'll be a short survey also, and if you'll take that survey, it just asks whether you thought this was worthwhile and that kind of thing. You take that survey and complete it, then at the end of that survey you'll get the HRCI information for your recertification credits. So hopefully we can get that to you as well. Now my information is on the screen. Feel free to send me an email. If you have specific questions about your circumstance, or give us a call, feel free to do that. Our phone number will be on the email you get later on this afternoon. Feel free to do that. Give me a call if you've got specific questions about what you're doing. If I can help, I'd be glad to, even if you're not one of our customers. And if you are one of our customers, please call me, because We've been in business 16 years. We've never had a lawsuit or a complaint on our, on our insurance or anything like that. And I don't want you to be the first. So if you're not 100%, 110% sure that you're doing everything right and you're one of my clients, call us. We'll take care of you. That's who we are. And finally, if you don't just absolutely love your current background screening relationship, you'll love working with us. We're based here in Fort Worth, Texas. All our employees are here, and I'm going to get sent to call centers in outer Mongolia or wherever. And my folks that you'll talk to are great people. We've got a great culture here, and they're actually analysts, not just call center operators. So you'll talk to the people who actually do reports all day when you call, and they will answer your questions. And if they don't, you call me and I'll answer it. So anyway, if we can be of service to you in your organization, we'd be thrilled to. So I appreciate everybody sticking around, and if there's anything else we can do for you, don't hesitate to reach out. Thanks a lot.